Hello and welcome to Legal Briefs, and today we are talking about DPP, the Deliberative Process Privilege in the Ripple versus SEC case. Now, if you feel like I've talked about the Deliberative Process Privilege before, Deliberative Process Privilege by the Deliberative Process Privilege, the Deliberative Privilege is, well, that's because the DPP issue has been decided 3 times already and it just won't die. In fact, here's video of one of the Ripple lawyers trying to kill that issue at a court hearing recently.
Die! Die! Why won't you die? Why won't you die?
Beneath this mask, there is more than flesh. Beneath this mask, there is an idea, Mr. Creedy. And ideas are bulletproof.
That was from the movie D is for Deliberative. Welcome back, and watching that clip from V is for Vendetta reminded me that the movie was about a horrible virus that led to government tyranny and then of course the ensuing fight for liberty. And we will be talking about tyrannical governments at the end of the video here, as it looks fairly obviously now where and how the bank lobby, the SEC, will attack crypto and where it will attack first. But before I get there, I do want to bring you up to speed on the immortal DPP issue and what is going on with that. And then we are going to play Let's Speculate about what it all means. The first time we heard about the DPP privilege was way back in March of 2021, and now it's early 2022. And guess what? The issue is still around after more than a year and numerous orders, and that is not normal in litigation. And so that of course gets my attention. Where there's smoke, there's fire, and there's some heavy smoke coming out of this issue regarding these emails surrounding the Hinman Ether is not a security speech, and we are going to understand what is going on legally and then do some speculation about what it possibly might mean. So go back in time with me to March 2021. Now this was pre-Delta variant and President Biden had just taken office. He didn't know it yet, but he did. So in March 2021, Ripple filed a motion to compel production of documents, and the SEC responded with a 10-page brief, and out of the 10 pages, it raised the deliberative process privilege in a little throwaway paragraph at the end, and here is basically what it said. Quote, several of the requests seek information covered by the deliberative process privilege and the attorney-client privilege, but the decision-making process of a government agency are protected from discovery by the deliberative process privilege. Now that's from page 10 of the brief. Now, there was a hearing in April of last year on the production of these documents, and Judge Netburn basically said that the SEC had to produce more formal internal documents regarding Bitcoin, Ether, and XRP. Okay, fair enough. So after that order, the SEC sent them right over to Ripple, right? Wrong.
It never happened. It never happened.
No, instead, the SEC filed another motion on May 6th of last year asking for clarification, and after reviewing that motion, once again, the judge ordered certain internal SEC docs to be produced. So of course, after that second order, the SEC sent them right over.
It never happened. It's false. It never happened.
Thank you, Mr. Jonathan Frax. That's correct. It again never happened, which then led to another Ripple motion on August 10 of last year, again demanding the documents, with the SEC replying that it didn't have to provide them, and this time relying squarely on the deliberative process privilege, which then led to a hearing with the judge on August 31 of 2021, at which time she said she would review the documents and make a determination after each side submitted briefs about each document. And it took a while, but that determination occurred recently on January 13 of this year, and I'm going to focus on what has become the main issue in this fight, and that is a fight over 66 documents from various individuals about Hinman's Ethereum is not a security speech. Now, Judge Netburn reviewed a representative document in camera, or in private, and what she said was very interesting. From page 13 and 14 of her order, first, look at how she frames the SEC's position. Quote, the SEC claims that an email enclosing a draft of Hinman's June 14, 2018 speech is pre-decisional and deliberative because then Director Hinman was seeking feedback from other SEC employees about the speech's contents before its delivery, and SEC staff were therefore in deliberation about the speech before a final decision was reached as to its language, close quote. So, having framed the SEC's position as being deliberations about the speech's content, the judge then goes on to point out, quote, "The personal views of agency employees are not protected by the privilege unless they bear on the formulation or exercise of policy-oriented judgment," close quote. So, then having laid out that the deliberations were only about the speech, and then that personal views are not protected from disclosure, she goes in for the kill. Quote, "The question of whether Hinman's speech reflected his own opinion or the agency's is settled. Director Hinman's speech expressed his own view. Indeed, the SEC has publicly disclaimed responsibility for the speech, which does not necessarily reflect the views of the SEC or its staff." And then she concludes, of course, that emails concerning the speech are not deliberative and therefore not subject to DPP protection. And that was on January 13. So now, finally, the SEC has turned them over, right?
Wrong. Not this time. Not this time. You're wrong. Not this time. It never happened.
Thanks, Jonathan. He's correct. Instead of turning over the documents, the SEC on January 21st did something rather extraordinary and asked the judge to reconsider her ruling from January 13. It's literally called a motion for reconsideration, and it basically says, "Judge, you messed up, and I'm giving you a chance to save face." In this case, the SEC is arguing that the judge didn't review numerous other documents related to Hinman's speech, and that if she did, she would change her mind. And this is literally what the SEC then says at the bottom of page 1 of its motion. Quote, "The SEC respectfully submits that these additional documents clarify the truly deliberative nature of the discussion surrounding the speech across the SEC and show that the speech was not merely peripheral to actual policy formulation, but was in fact an essential link in the SEC's deliberative process with respect to Ether and other digital assets." Say what? Now, I had to read that a couple times because the SEC has been so adamant that Hinman's speech was just his personal opinion, and now, are they arguing that's not the case? Or, I mean, it actually looks like they're now arguing that the SEC had or has an official position on Ether that Hinman's speech contributed to. If that's the case and the SEC has an official position on Ether, someone should tell Chair Gensler because I don't think he's seen that yet. And if that exists, then surely that's an official position and it's discoverable by Ripple. So maybe Ripple needs to see a copy of that decision about Ether. Just saying. But putting that aside for a second, look at what else the SEC is asking for, and this is where it gets frustrating. The SEC in its motion asks for, yes, another extension of time, because normally you only have 2 weeks to move for reconsideration, and here's the SEC asking for it. Looking at page 2, quote, "The SEC further seeks leave to file a 20-page, double-spaced brief in connection with the motion. Finally, the SEC requests that the court extend the deadline for the SEC to file the motion, which is currently due on January 27, by 3 weeks to February 17, 2022. So yes, the SEC is pleading with the court that it needs 5 weeks to file a relatively simple motion for reconsideration, and the frustrating part is that the judge granted an extension in part, and this is the SEC's 4th extension. It's like as soon as I lock down an end date for this case, the SEC asks, and the judge keeps allowing it to be pushed back. But wait, it gets worse. If Judge Netburn sticks with her original order that the Hinman speech-related emails have to be turned over, the SEC then can appeal that decision to the main judge in the case, Judge Torres, and that will take at least another month for that process to take place, and that takes us into March or April before this issue is concluded with Judge Torres, and then even though all other discovery might be concluded before the end of February, now how does Ripple draft and finalize a motion for final judgment when it doesn't have all of the evidence yet? So that brings you up to speed on the DPP issue. The SEC just won't let go of those documents. It's like a pit bull mauling your arm, or at least holding on to its favorite toy. The SEC just won't let go of those emails, and this has finally got my attention because although the first 2 times it lost and just wouldn't provide them, it was a little strange, but this last motion for reconsideration is not normal. I mean, I've only filed 2 motions for reconsideration in like 20 years of practicing law, which brings us to my favorite segment of legal briefs, speculation time. And here's my Uncle Johnny to introduce the segment.
Okay, to speculate means to make inferences, to make guesses based on inconclusive evidence.
We keep them in the basement. So, really, what is going on here? When I saw this last motion for reconsideration, the first thing that came to mind was that this was a delay tactic by the SEC, especially when you consider that they were asking for essentially 5 weeks just to file a motion. In fact, there is no doubt that this was at least in part a delay tactic. But a delay for what? I litigate mostly against insurance companies, and they always want to delay because they can keep more money in the bank longer, plus they can kind of wear my client down who's just a person. Now, that's their incentive, and yes, the SEC does maybe have some of that incentive here because Ripple wants this case over and the SEC doesn't care so much about time. But that kind of litigation pressure is only applicable really in this context if the SEC wants to put pressure on Ripple in order to place itself in a better posture. That's right, delay doesn't help the SEC at a trial or summary judgment hearing. It really only helps it to get the case. That's the only true valid purpose for this type of extended delay, to put pressure on Ripple. Not pressure on the judge, but pressure on Ripple. And there's a second, even more interesting possibility that could be going on here, and I have not jumped on this bandwagon before, but this last week I am on it now because what the SEC did last week is really extraordinary. And that other thing that could be at play here is that among the 60-some documents related to the Hinman speech, there could be something really, really bad for the SEC in there. And when I say bad, I mean something that really just destroys the SEC's case. Now, what that could be, I'm not exactly sure, but it'd have to be pretty bad in order to justify the legal gymnastics that the SEC have been playing on this issue. And yes, there of course could be other things it could be as well, but I would say those two are the most likely. Either the delay is a pressure play on Ripple, or there is just something so bad in those documents that the SEC is willing to make some strange legal arguments in order to hide it. And while we are talking about speculation, let's take a gander at exactly how the US government is going to attack crypto, because I think it's become fairly obvious at this point. And I had already decided to touch on this topic during this video, and then guess what I saw on Twitter yesterday from Fox Business's Eleanor Terrett. Quote, "The Biden administration is planning executive action to regulate cryptocurrencies as a matter of national security," close quote. And then you can see there below that she gets some additional information and says that the order is actually coming out next week. And in my mind, I went back to high school and my teacher always said, "We study history because history repeats itself." And I would just roll my eyes, think, yeah, whatever, boomer. But now at 50 years old, I finally see he was correct. I apologize, Mr. Riley. Because let's go back to 1933 and President Roosevelt's Executive Order 6102, which in short outlawed ownership and confiscated gold, and it was considered a matter of national security also. And how was the gold confiscation order enforced? Did armed FBI guys bust into people's homes and search their homes for gold? No, that doesn't work too well, especially in America where everyone owns a gun. No, the only practical way for the government to control an asset like that is through the refineries and the gold importers and the exchanges. And that is exactly what the government did back in the 1930s. And if we fast forward to 2022, I think it's obvious that if the US government really wants to regulate, confiscate, or even outlaw crypto, the only viable means is through the exchanges. The SEC doesn't have the ability to sue all 10,000 crypto coins out there. And even if it did, the crypto world is so global that as soon as it sued 100, another 100 would pop up in another country. And sure enough, a week or two ago, Chair Gensler signaled just that, and here's the news story from Yahoo Finance. Headline: SEC's Gensler wants crypto exchange regulation in 2022, warns on stablecoin. And later on, we see that this is a coordinated operation. Quote, the SEC chair says he's asked his staff to get crypto trading platforms inside the investor protection remit, underscoring that he's talking regularly with regulators at other agencies, including the Commodities Futures Trading Commission, the Comptroller of the Currency, Treasury, and the Federal Reserve. All of those principles are also vectors of crypto exchange and stablecoin regulation. And so now you know exactly how the US government is going to corral in the crypto cattle. Enforcement actions against the exchanges. If you can get the exchanges in the barn, we are all in the barn as well. And now I see that my high school history teacher was right all along. History really does repeat itself. Thanks for watching. Oh, you're still here? Well, listen, I don't normally do this, but today I'm going to shill you a coin. Guys, it's almost Valentine's Day, and I hope you have got something for your special someone. But if not, take a look at these coins from my friends at Hatton Souvenirs, link down below. Get her an XRP coin. This XRP is fast and cheap, and the coin will remind her of you. And they even have one for your ex-wife. Enjoy.